So she would actually defy a court order and go on vacation, even knowing that she's got to come to court? Not cool, man. Tell her that I'm not happy with her. Like, I'm not happy at all. Where is she?
She's in Maui, Judge.
Life is good for some, I guess, right? A court date is a court date. You willfully chose to just defy. We have DWI after DWI, death after death. It's truly an astounding and a disgusting statistic. And when you go home, I want you to tell him that he should be ashamed of this. He should be ashamed of himself.
This case begins with a 23-year-old woman who is arrested for driving while intoxicated and given a scheduled court appearance. Instead of treating that date as a serious legal obligation, she decides not to attend because her family already planned a vacation to Maui. Her attorney contacts the judge requesting a new court date, almost as if the hearing were something minor that could simply be moved around. But this situation unfolds in Harris County, an area known for having one of the highest numbers of drunk driving fatalities in the country. That context makes the choice even more troubling. While the court deals daily with the consequences of impaired driving, the defendant appears to place a leisure trip above a mandatory bond hearing. By the time the issue reaches the judge, frustration is already building. It raises a straightforward question. When facing a serious charge like DWI, would anyone reasonably put a vacation ahead of their responsibility to appear in court?
Do you have
I have a similar situation to Mr. Johnson. I have a client who's a new DWI arrest. She was a .084, 23 years old, no priors at all. Whitney Dela Cruz. The only difference is she is actually out of the state right now on a vacation that she took with her parents to celebrate their 24th wedding anniversary.
So she would actually defy a court order and go on vacation, even knowing that she's got to come to court? Not cool, man. You know?
Well, I think it was a family event that they had all planned and had prepaid for. She'll be back in town on Monday.
That's really arrogant. You know, would you do that?
Well, obviously I wouldn't do that, Judge, but
I wouldn't do that either. I mean, when is she coming back?
She'll be back on Monday, and she'll be back in Houston on Monday, and I'm going to have her in court first thing on Tuesday, Judge. I will grant you the courtesy of Monday, but I mean, it's not cool that you would defy a court order and still go on vacation knowing that you have to come to court. That's a kick in the ding ding, man.
As the attorney explains that changing airline tickets would be costly, the argument quickly begins to sound less like a legal justification and more like a personal inconvenience. Financial concerns about travel plans simply do not override a direct order from the court. The judge listens, but the explanation does little to strengthen the request. Whether the vacation was planned or even paid for by family members is ultimately irrelevant to the court's expectations. What matters is that a defendant who has been charged with a crime must appear when ordered. From the court's perspective, the message it sends is that the hearing was treated as optional. Judges rely on compliance to keep the system functioning properly, and failing to appear, especially for a reason like a vacation, can easily come across as dismissive of the court's authority.
You know?
Well, I understand. I think it was a situation where her parents had prepaid for the entire thing for the whole family and didn't want to have the expense of trying to send her back alone early.
Where is she?
She's in Maui, Judge.
Life is good for some, I guess, right? I'll set it for bond forfeiture for Monday. You know, see what you can do.
Okay.
I mean, I can't believe that someone would really do that and still go to Maui. I don't. When on Monday does she get back, Mr. Mays?
Oh, I will have to ask her that, Judge.
Yeah, tell her that I'm not happy with her. Like, I'm not happy at all. It's just not cool.
Really. I understand.
So just get back, just get a hold of me and let me know.
Okay. Thank you, sir.
Okay.
I'm here on Whitney De La Cruz. It's off the docket. I'm appearing for Nathan Mace. It was, I guess she had a warrant. She had a family trip that was booked for 6 months. It was her parents' anniversary. I don't know. I'm just filling in, but I'm just trying to see if we can.
Yeah, she chose to go on the trip instead of coming to court. Basically, what happened. I mean, I get that she's
president of the gallery, Judge. She's never been in trouble before. I understand.
Is that her?
Yeah, that's her.
Can you bring her up?
Can you need a contact with her?
Yeah. what is it?
The trip had been booked for 6 months.
I get it, but that doesn't justify it. You know, a court date is a court date. And you willfully chose to just defy and say, thumb yourself at the court system. And that's not cool. That shows us that you completely disrespect. You don't care what we say, what we think. That's not how we do things in criminal court, it's especially in light that this is a driving while intoxicated case. This is may not be a big deal to, high-priced lawyers, but to us, we treat this as a big deal. Harris County leads the nation in DWI fatalities. We have DWI after DWI, death after death. It's truly an astounding and a disgusting statistic.
The tone of the discussion shifts noticeably when the judge highlights a broader reality. Drunk driving remains one of the leading causes of traffic fatalities in the country. At that moment, the focus moves away from scheduling conflicts and back to the seriousness of the charge itself. A DWI case is not simply about paperwork or courtroom procedures. It involves conduct that can endanger lives on the road. That perspective reframes the situation entirely. What may have been presented as a minor inconvenience suddenly stands against the backdrop of a major public safety concern. When a defendant treats the situation casually, it can appear out of touch with the real risks associated with impaired driving. It is this contrast, between the gravity of the issue and the casual handling of the court date, that clearly frustrates the judge.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
On June 1st, 2024, officers were notified by the police department requesting assistance if possible at 7:36 in the morning in the target parking lot. Officers advised the suspect was involved in a minor car accident. The driver was identified by her Texas driver's license. Officers could smell a strong odor of alcoholic beverage emitting from the defendant and observed that she had glassy eyes. The defendant stated that she had 4 shots in the backfire. They conducted standard sobriety tests, 6 of 6 for the HGN, 2 of 8 for the walking turn, 0 4 for the one leg stand. Officers wrote the DIC, and the defendant consented to arrest, as the results of which were 0.085 and 0.084.
Okay. Can you do me a favor? I guess look to see what other kind of contacts she has with the law. Does she have any priors, any WIs?
She's never been in trouble before. I've got a chief approved PGI offer today. I understand the court's concern. She was not willful, and I know how it seems.
But
I know what you're saying, Judge. I'm just telling you, she's scared for her life. She's never been in court before. She showed up today. She's not on docket today. She's trying to make it right.
If it were me, if I know I pick up a DWI and I have a court case the following week, I'm going to go. I don't care if I have a trip,
At one point, the judge comments that people sometimes come from very different backgrounds, a remark that carries a deeper meaning about personal responsibility. In the courtroom, accountability is not negotiable. Regardless of upbringing, social status, or family support, the rules of the legal system apply equally to everyone involved. Court orders are not flexible suggestions that can be rearranged around personal plans. Instead, they represent a fundamental part of how justice is administered. When a defendant places something like a vacation ahead of a required appearance, it clashes directly with the expectations of the court. The system depends on individuals recognizing that legal obligations must take priority over personal convenience.
To me, and I guess other people come from a different cut, but the court system takes precedence over everything else.
I agree, Judge. I'm asking for leniency in this case. She's not a career criminal in any way.
In life, Mr. LaCruz.
I work at my dad's company. I do paperwork, invoicing.
So non-destructive testing for oil fields, Judge. She's admin there at the.
How old are you?
22.
Did you graduate high school? How far did you make it?
I graduated high school and I just been working for my dad for a couple years because he had a stroke and he needed help with the company, so I came in and stepped in.
For future reference, this is not the way we do things. And if you ever do this to me again, or us, I'm going to hold you in contempt. That's how seriously we take it. And it's really it's a slap in the face of the entire criminal justice system to tell us that you'd rather go on a trip than to come to court when you're supposed to come to court.
My dad is assistant of the and I told him I have to stay here and
then your father should be ashamed of himself. And when you go home, I want you to tell him that he should be ashamed of himself and that It's not the way we do things. I will reluctantly keep your PR bond in place, or I'll reinstate your bond. I'm going to tell you now, this is the only get out of jail free card that you're going to get from me. You will never get one again. If you ever miss court when you're supposed to be here, you pick up a new case. If you consume alcohol or drugs, I'm going to put you in jail. You will never get another PR bond. You understand, man? So I am going to find probable cause. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or dope, you will go to jail. Tell me, do you have a Texas driver license? Do you have liability insurance in your name?
She has insurance. It's under her father's name. She's on the policy.
I want to make sure that you're named as a covered person. If you are, then you may continue to drive. Until that point, I just want to know that you're actually a named under that policy. You have a lawyer. You must stay in contact with the lawyer, which I hope that there won't be a problem.
There's not an issue, Judge. This will never happen again. It's fine.
I get it. If they come back to me and tell me that you've gone MIA, I will issue a warrant for your arrest. So you must stay in contact with them and they will tell you when you have to come back to court. For now, I'll have you go to Victoria. We'll have you sign a reset. After that, you'll get with Trace for your bond conditions, and then
it's set 6-7. Can we go?
We're gonna
we'll
reinstate the bond now, and then we'll just let you pick a new date.
Thank you, Judge. May we be excused?
Please.
In the end, the judge allows the defendant to remain free on a personal recognizance bond, meaning she is not required to post money for release. However, the court makes it very clear that this outcome should not be mistaken for approval of her earlier decision. The judge warns that the opportunity being given is essentially a final chance to demonstrate responsibility moving forward. Situations like this often highlight the tension between privilege and accountability within the legal process. While someone may receive a break once, the expectation afterward is strict compliance with every court order. The case also raises an interesting debate for viewers and observers. If you had an important trip planned, would you ever risk missing a required court date? Ultimately, the lesson from this moment is simple. When the court calls, personal plans must come second.